Welcome to Feed Your Dog Facts, the internet's #1 resource for fighting pet food industry misinformation and promoting evidence-based pet care. Now, here are your hosts, Daniel Shuloff and Alexis Malone.
Hello, everyone, and welcome back to another episode of Feed Your Dog Facts. My name is Alexis Malone. I am your host. I'm alongside Daniel Shuloff. He is the CEO of Keto Natural Pet Foods, also the author of Dog's Dog Food and Dogma. So today we've had a big development in your world, Daniel, which is why we're actually releasing this podcast a little bit late. Typically, we release on Friday. Been a little bit late, but I'm hoping you can fill in the blanks as to why.
Yeah, sure. Yeah, the reason that life has been so busy recently, as we record this on February 23rd, is that about 2 weeks ago, lawsuit was filed on behalf of Keto Natural Pet Foods, the company for which I'm the CEO. And it's a lawsuit that's kind of high profile. To the extent that like pet food lawsuits are high profile, this is that thing. And so, we're going to talk about the suit today. And that's kind of the purpose of this episode, is to give everybody an introduction to it, because a lot of folks will be tuning in having heard about it already. But we want to make sure, and so I'm sure everybody has questions and we want to address it. But that's the reason why we're running kind of behind schedule. There's a lot of balls in the air. When you file a lawsuit that gets media attention, you need to do a bunch of media related stuff in connection with filing it. And so that's all just been kind of piling up. And so it's pushed this back a little bit later than we wanted to. I'm sure also so I already wrote a blog post that this is in essence like the podcast version of. And if you go to our website, ketonaturalpetfoods.com, you'll be able to find that. It provides a nice textual overview of what the suit is about. But today we'll talk about it too, because it helps to bring it out in different kinds of ways.
Yeah, so I'm hoping that we can start with the summary of the suit and then kind of go from there. And at the end, we'll let everyone know where they can submit their questions if they do have questions about the suit. And then, I suspect that we'll probably do a Q&A follow-up later on. So
totally. I hope that is the case. All right, so let me do the summary and then we'll kind of get into it. Why? Because I think it will produce questions, I would hope. So the lawsuit is a class action lawsuit filed against Hill's Pet Nutrition, along with two nonprofit organizations that are affiliated with Hill's. One is called the Mark Morris Institute. Mark Morris was the founder of Hill's, so it's the Mark Morris Institute, named after the founder of Hill's. The other, which is somewhat well known in the animal welfare community, is called the Morris Animal Foundation, named after the same guy, the founder of Hill's. So those are three of the defendants in the lawsuit, Hill's and these two affiliated organizations. And then there are 5 individuals that are also defendants in the lawsuit. They're all veterinarians that work at major research universities. They're kind of research vets primarily. Though I think, I'm not 100% on this, but I think most of them have some degree of clinical practice as well. Those are the 8 defendants in the lawsuit. Keto Natural is the plaintiff in the lawsuit, but it's a class action. It's framed as a class action lawsuit. What we're essentially asking is for the court to resolve it. What we're saying is, look, Keto Natural has all these claims against these 8 defendants, but court, so do all these other companies that are in a similar position to Keto Natural. As I get into the substance of the lawsuit, I'll explain what kinds of companies we're talking about. But what we're saying to the court here is Keto Natural is bringing this lawsuit on, and we want to represent everyone else that falls into this class of folks that is just like us. They've all been damaged by this same core set of allegations. And that's a legal vehicle that's existed in the United States for a long time. It exists for a variety of reasons, but one of them is it just makes up for a more efficient resolution of case claims involving that, where there's a lot of victims, but it all kind of stems from the same set of factual allegations. 100 different lawsuits all about whether people did one set of facts or didn't. It's inefficient for the court system. It's easy, and for the litigants, it's easier to manage it all in one place. There are a variety of other things, but like generally speaking, this is a well accepted legal vehicle. One of the things that's notable about the fact that this is a class action here is it means that the what's called amount in controversy, the like value, the size of the lawsuit is really large. So Keto Natural Pet Foods is certainly not a billion-dollar company. But the amount in controversy in this lawsuit at this stage, the things change throughout the lawsuit. It could grow, it could shrink, we'll see. But based on the evidence that's available right now, the amount of controversy is $2.4 billion. So it's a much larger number than Keto Natural could ever claim to be damaged by any set of misconduct at this point. We're just not that big a company where we've lost $2.4 billion in business. But when what the $2.4 billion represents is the amount that we think everybody within the class has been damaged collectively. So that's why the number is kind of so big and punchy. Anyway, yeah, so those are some of the things. The substance of the lawsuit also makes it noteworthy, and like newsworthy. And the substance of it is the dilated cardiomyopathy, DCM controversy. If you're listening to this, you probably already remember this, but DCM became the hottest thing in pet food for a period of time beginning about 6 years ago, in 2018. In essence, what happened was the United States Food and Drug Administration, kind of out of the blue, announced, we are looking at whether this big group of pet food products all cause dogs to develop DCM, this heart disease that's horrible. That's like a legitimately very scary kind of disease that kills dogs for real. It's like your heart, their hearts get like larger and kind of leakier is like the word you hear a lot with it. But it's a very real disease. And to one degree or another, the veterinary community has been aware of it as a disease, and one that has kind of well-documented ties to certain nutritional issues for a long time. There are requirements. So like when you sell pet food in the United States, you need to make sure that the nutritional content meets certain like profiles that are established by the Association of American Feed Control Officials, this regulatory body, AFCO. The AFCO says, like, if you want to sell your pet food as complete and balanced in the United States, it needs to have this much vitamin A, this much, essential like fats, proteins, etc. And some of those requirements are like directly about DCM stuff. Like if you feed a dog too little cysteine or methionine, those are two kinds of amino acids. It's been shown that the dog is much more likely to develop DCM. And that's kind of why there are cysteine and methionine level requirements in AFCO's regulations. But anyway, the FDA didn't use the word cysteine, methionine in its announcement. It said, we're investigating this whole big class of products. And the class of products has like how that group is defined is an important issue in the lawsuit. And it's not been consistent across the various groups of folks who have talked about the DCM controversy in the 6 years since the FDA announced its investigation. There's some ways that the FDA talks about the group. There's some ways that the media has tended to talk about the group. And then there are some ways that the defendants have tended to talk about the group. But generally, for the purposes of this discussion, what we can say is like they kind of focused it on grain-free dog foods. That was the way that the products that were made subject of the investigation were kind of described in the major media coverage that the FDA's announcement got when they announced it in the summer of 2018. And so the reason this was such a big news story was, or one of the reasons, right? Like the United States Food and Drug Administration looking into whether a very big group of products cause a fatal disease is like legitimately newsworthy, of course.
If you have not heard of it, then just type it into Google and you'll get all sorts of articles.
Yeah, sure, exactly. But like when the New York Times ran a big piece about the investigation, they said, in essence, paraphrasing here, are grain-free dog foods, ... linked with this disease or whatever. And they were not the only outlet. Washington Post, like everybody covered it more or less. And as you'd imagine, it freaked pet food consumers, pet owners, veterinarians, freaked everybody out. It was a huge deal. Like the idea, like, whoa. This class of products, which at the time of the FDA's announcement was like, a major fraction of the US pet food market. If you're talking about just grain free, you're not talking about 1% of the market. You're talking about a huge chunk of the market. Okay. Tens of millions of dogs are eating those products every day. And, this might be going to kill them. Like, that's a freaky thing. And so it freaked everybody out. It had huge implications. Okay. It damaged, as you could imagine, if you sell the kinds of products that the FDA is saying, well, we're looking at whether these things cause a heart disease. Yeah, your products don't do too well in that kind of an environment. And so it had huge market ramifications. Yeah, maybe that's like a good place to, there's more that's taken place since then. I'm trying to like delineate between like giving background and then talking about like the actual allegations in the lawsuit. But like a little bit more background is like what happened from there. Like, okay, big, colossal firestorm when the FDA announces this, then what? So over the next 6 years, so this was before COVID, okay? This is like, goes back a minute. So as for like when the FDA announced its investigation, the investigation has, in essence, been proceeding ever since. The media coverage has like trailed off big time. Like in the wake of the announcement, big headlines. Then over the like 12 to 18 months-ish that followed, the FDA issued a bunch of updates to the public. And when those things would happen, at first they would get major media coverage too. Like the Washington Post would publish a follow-up article, new FDA announcement says blah, 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 blah. Over time, both of those things have trailed off. The frequency and kind of substance of the announcements, as well as the like media saliency, like the media it slowly drained away. And then recently, at the end of 2023, the FDA put out an announcement. So this is now, almost 6 years from the time it launched its investigation. And in the intervening 6 years, like the entire COVID pandemic came and went. Okay. And like, think about all that the FDA had to do in connection with that, had to manage a like civilization threatening pandemic and there are all kinds of things you could say that the FDA did well or not well in it. But at the end of the day, a disease that had the capacity to like completely remake world civilization on a kind of permanent level got managed to a point where now most people are back to work at offices and, life is going on. But like, I just mean to stress that all that happened between the time they launched the DCM investigation. But anyway, in late 23, FDA said, we're not saying we're stopping the investigation, but we are saying we're not going to do any more updates because we haven't actually found any evidence that these products cause this disease. In that period of time, 6 years, something like that, a lot of peer-reviewed scientific papers got put out about DCM and grain-free diets. And the FDA, in essence, was saying in late 23, look, between that, the body of evidence that's been produced, and our investigation, like their investigation is not just we're reading the peer-reviewed record and trying to figure this out. They're collecting cases from like, that's sort of a key part of this is when the FDA says it's investigating a subject, part of what it means is that people are telling the FDA when their dogs get this disease and under what circumstances, what diets they're eating, et cetera. And the FDA is trying to figure out whether that data helps them establish that these products are causing this disease or not. And in late 23, the FDA essentially said, at this point, you can never in the world of science like say we have proved that it does not happen. That's not like a thing. But you can say we have no evidence that this is a thing. And that's what they in essence said in late 23. And so they said, we're not going to issue any more updates because of this unless there's some new development in the science. And the science shows us that there is evidence that these diets cause this disease. And so that was sort of like, in a lot of people's eyes, I think, that was the end of the DCM fiasco.
So to clarify quickly, the FDA has stated we are no longer investigating this matter because we have not found any evidence. They have not come out and said there is no link, correct? Like they have not.
Yeah, and that's right. It's like you can't, it's sort of like one of the most important lessons that I hope that the veterinary nutrition and clinical veterinary communities and the lay public take away from the DCM controversy when the dust all finally settles is science typically uses precise, specific, meaningful language when describing the kinds of issues that are being investigated. And in the case of the DCM controversy, that lesson, that practice, that custom got lost. And you have a lot of folks that, in my judgment, intentionally used very general language that had ramifications. And so you can't, in the world of science, prove a negative, in essence. It's like, that's not a thing. They can't say we have proof of no evidence. They can say there's no evidence. They can't say we have proof it's not a thing. That's not ever the case. There might always be some evidence that develops that supports the theory. And the FDA is like kind of leaving the door open to that, is in essence what it said. Is like, well, look, enough time has passed for a whole pandemic to come and go. We have dozens at this point of papers that have been focused on this subject. And we've been doing our own investigation. We've been looking at cases coming in for 6 years. And at this point, we don't see anything. And that's in essence what the FDA was saying now.
And so I want to get into what the lawsuit actually says. But first, my next follow-up question is that, so once the FDA opened their investigation, they invited everyone to submit cases so that they could look into this issue further. But what actually started the concern?
Yeah, okay. So this is a super important subject. So the FDA, one of the things that it does, so the FDA has like regulatory authority over some aspects of pet food, plenty of aspects of human use products, both food and drugs. And one of the like ways that the organization operates is it has online reporting portals. So you can at least, and I think this is the case with human products as well as doggy ones, but you can say in essence, it's 2021 and COVID is raging and you buy Ketona for the first time and you start feeding it to your dog and 2 weeks later you get COVID. Well, you can submit a case to the FDA and say, look, I fed my dog this product, Ketona, made by Keto Natural Pet Foods, and me and my dog both got COVID. So I'm worried that this product gives your dog COVID. And the FDA takes that information, applies the principles of science, of statistical analysis, and does its best to figure out whether all that, it's like a nice centralized hub for reporting data to the government about important potential links. And that existed prior to the announcement of the DCM investigation. So on the issue of like what kicked it off, the place to start with it is what the FDA said and what was reported in the media. And what the FDA said was, we have received a spike in cases of dogs that are eating these kinds of diets, what we're calling for this purposes of this discussion, grain-free diets and DCM. And sounds to me at least like a perfectly legitimate reason to launch an investigation into whether those two things, that diet and that disease, are somehow linked together. Like if the number of cases of DCM that get reported to the FDA by US citizens every year is very low, and then 1 year out of the blue, it starts spiking. Well, one thing that could explain that is much more DCM is out there happening, and it's being caused by a specific subset of products. And so the FDA's got to look at that. And that's in essence what they said. They use that language, a spike in cases, a lot. So that's kind of what kicked it off. That's what the public always understood about what kicked it off. And now we're sort of getting into like how this lawsuit came to be. But when I heard that, and when some other folks that I'm familiar with within the pet food industry, the veterinary nutrition communities, heard that it felt suspicious. It felt wrong-ish, like not in any specific way, but it felt strange. It felt like that something's either incomplete or funny business there. That doesn't sound right. So like generally speaking, here, like I speak for myself. Number one, the FDA, like the nature of the group of products that the FDA was framing its investigation as being focused on, what we're calling grain-free products here, is incredibly diverse. And so for there to be some sort of like thread between the diets and the disease, there has to be some kind of nutritional, biochemical, like explanation. Something has to run in common among all those products that gives rise to the disease, if that's indeed what's going on. And if you have like a 101 level understanding of the pet food industry, you know that that's not the case. That like grain-free pet food is a group that contains all of Keto Naturals products. It also contains like loads of, it contains everything from all meat diets, those don't contain any grains, to like vegan diets that contain no meat and are composed entirely of plant products. It contains raw pet foods. It contains fresh pet foods like the home delivery, farmer's dog type stuff. It contains kibble dog foods. It contains pet foods with tons of protein, very little protein. It contains, it's just like too much variety without any common underlying linkage for it to make sense. And that never got like teased out or explained in any kind of like persuasive way in the early days of the investigation. And so it catches your attention. It's like, well, that doesn't seem right. What's up there? In addition, I came into 2018 having already written a book about the messy space where pet food industry and the scientific community and the veterinary world and regulation all kind of overlap, and how pet owners and pet food consumers are being misled, in essence, about important topics that matter to the health of their animals as a result of that quagmire. And so I know a lot, like I spent 4 years working on that book. I know a lot about it. I know the organizations that are often involved in this kind of thing. I know the people that are often involved. You see the same names often, the same companies. You see the playbook, like how it's gone in the past, how some individuals have like engaged in quasi-science behavior that's had the impact of influencing consumer behavior, even when the scientific evidence propping up the recommendations is at best like shaky. And some of that was evident in the publicly reported details about the FDA investigation. Some of the people's names that I wrote about in my book are in the initial press coverage. Oh, that's weird. And they're people whose financial conflicts of interest, like on the same side, like lie with companies that stand to benefit from an investigation into grain-free pet foods. They're the companies that kind of don't make grain-free pet foods, if that makes sense. And so that's another reason that it's like, this is suspicious looking. This is like, I wonder what's going on here. And so it's had my attention, the like DCM controversy, for as long as it's been an FDA investigation. I've been like interested and sort of like skeptical about it. And of course, it's bad for my company. And so it's very salient to my work life.
It just seems like, well, wait a second, are grain-free pet foods new? Like, how long have they been around? How long has DCM been around? And if there was a correlation, would it have actually taken this long?
It's not like grain-free pet foods got introduced to the pet food market in 2018. So that, that's what you would sort of expect if indeed there was this linkage there. That's an excellent point. That's another reason, like, yeah, there's like people, and, speaking only for myself, but also conversations I have with other people, it's like people sort of were suspicious that something more than just a good faith investigation was taking place. So what do we do about it? Okay, so I'm suspicious. I'm a doer type person. I used to be a lawyer. And so one of the things I learned about as a lawyer and as a writer, someone trying to engage in a journalistic exercise, writing my book, is a federal law called the Freedom of Information Act. Freedom of Information Act says, in essence, that the government, subject to some exceptions, has to give citizens that government represents its records, unless an exception applies. So, for instance, if you want to know, it's like, in essence, what you're trying to say is you want to give government accountability. Taxpayers should be able to say, how is my tax money actually getting used? Show me the records that prove up what you're saying in public government. And as you can imagine, there are lots of instances where there are competing concerns that push back against that. And so there are like exceptions to that general rule. So for instance, I can't reach out and ask the government for your social security number or any, that kind of stuff, because you have a privacy interest in all that and I could take advantage of it. I can't reach out to the CIA and say, like, give me your whole like Russian misinformation file because I just want to independently investigate that. They're like, no, that's a national security issue. You can't just have that because it would risk our national security. So there are a variety of exceptions that are meant to address something like that. In my judgment, those didn't apply here. There were none of those that applied here. And so I said to the FDA, in an effort to try to understand if there was something more to my suspicion, give me the whole DCM file, in essence. And the FDA said, no, we don't have to do that. There's an exception here for ongoing investigations, and it applies to this case. You don't get to look at those files. And so I sued the FDA, and I said, they're not doing what they're required to do under the law. And the reason that, ultimately I won, like they gave in and they said like, okay, fine, we'll give you the records. And in essence, what they were trying to say was that like, this is an ongoing criminal investigation. Like if you're looking at whether Dan engaged in armed robbery, if the police department is investigating that and thinking about whether I'm a suspect for that, I can't reach out to that office and just be like, give me your whole Dan file, because they have an ongoing criminal investigation. It jeopardizes that. This is was an ongoing investigation, but for like a different reason. You know what I mean? Like it was or a different type of investigation. The government was trying to investigate whether some scientific phenomenon was real or not real. It wasn't subject to being its investigation wasn't compromised by like giving up any documents. And so that was kind of the key issue. Ultimately, they saw the light and said, fine, we'll give you the documents. And so starting in, I'll miss the date, but starting years ago, they started sending me one CD every 6 weeks that contained hundreds of redacted pages of FDA records about the DCM investigation. And that happened every 6 weeks for a period of years. And ultimately, they sent me something like 20,000 pages-ish of records. And they are, in a lot of ways, instructive about how that investigation came to be, to what extent the things the FDA said in public are true, false, or incomplete. And kind of it includes non-public information, I guess is what I'm trying to say. Is like it definitely includes information that was not a part of the FDA press releases, was not a part of the media coverage around it. And more particularly, it showed what I interpreted as smoking gun evidence of liability causing misconduct. That what it shows is stuff that should make people liable for damage caused by the FDA's investigation. And that's sort of why there's a lawsuit today. There are documents that got produced to me through FOIA that show things that are wrongful behavior that gave rise to an investigation that never found anything but hurt, companies, individuals, dogs, in a huge way. And ultimately, as I thought about, I have this evidence of this. What do you do with this? It was like, well, one thing you do with this is you sue the people that are at fault for doing this because they should be liable for this behavior. And so I did research into the best firms in the country for bringing those kinds of lawsuits, for bringing lawsuits that allege corporate misconduct that's either anti-competitive or bad for consumers or bad for shareholders of companies. There, alas, in this day and age, big companies do engage in bad conduct sometimes. And there are some law firms that are focused on bringing the kinds of cases that are meant to hold those companies accountable, in essence. Like often what happens when companies do things wrong is a lot of people get damaged in a small amount. And so they end up being class action cases. When they get sued for that misconduct, they end up being class action cases. It's like if, a telecommunications company adopts a new fee policy where they're like the blonde hair exception and you get charged $5 extra for it. Okay. Everybody that is a customer of the telecommunications company that has blonde hair is going to pay $5 extra. Every one of those people that has blonde hair might be like, that's not fair. That's not lawful. You shouldn't be allowed to do that just because I have blonde hair. But the amount's only $5. So it's like, are you really going to sue a telecommunications company over that? And the answer is oftentimes no. There's not enough money at stake. It would cost more to litigate it than it would be worth. And that's another reason why class actions exist, is because that might not be worth it for one person, but you still want the legal system to hold that company accountable for misconduct. And so class actions provide a vehicle for doing that, where it's like, well, this individual may have only been damaged by $5, but the 1 million customers that have blonde hair, collectively, it's $5 million. And that's worth a lawsuit. And so there are law firms that do those kinds of cases. So I found the best ones. I approached some of them about like, well, here's, we got talking about what I've got and whether under the eyes of the law represents a theory of liability. Here's my evidence of the misconduct. Here's what I would say to them, and they would say to me, well, here's how that evidence lines up with liability. Like, this is why we do or do not think there's a case based on this. And so there was a lot of interest. And ultimately, in the summer of 23, I formed a attorney-client relationship with one of the best firms in the country. So they're called Wolf Haldenstein, Adler, and Hers. Pretty sure it's like got 5 names. So let me just make sure. Adler, Freeman, and Hers. They've been around since the 19th century. And so I assume Mr. or Mrs. Freeman won't be offended. But anyway, yeah, that's Wolf, Haldenstein, Adler, Freeman, and Hers. They're into it. They do this kind of thing at a very high level. They've recovered billions of dollars for classes over the years. We put together, working collectively. Like I said, I'm a lawyer. I have done this kind of work. And so I understand the process as well. We worked pretty collaboratively over a period of months and put together the suit and filed it in February 6th, like the first week of this month. And that's the origin story of the lawsuit.
What if some of the reactions to the lawsuit, what have they been? But I think more importantly, what are you hoping that this lawsuit brings?
Okay, so in terms of what the lawsuit brings, what we're looking for, what we've asked the court for are a few different rulings. One is damages award, that you can reduce to financial terms the kind of damage that has been done to our class by the defendants. And so we are saying to the court, because these people did these things and because the law is what it is, they should be liable to us for this amount of money. And so that number, like I said before, is $2.4 billion for everyone, that all the pet food companies that have been damaged by the wrongful perception that their products contribute to giving dogs DCM. That's one thing we're asking the court for. The other is what's called injunctive relief. And that's like the court can order some things that are not just you pay this person that much money. It's things like you stop doing this, you stop saying that, you stay away from those kinds of things. And so those are kind of the 2 categories of relief sought by the court. Though there is more to it. Like, I think I should give an outline of the actual nature of the allegations, like what the wrongdoing here is. But one of the things that'll come through, I'll just do that in a second. But I guess just to answer your question, the misconduct here, as we allege in the complaint, is not just an isolated thing. Like, the DCM playbook was the same playbook as has been used by the same individuals in the past to achieve. And the result of having done that in the past was quite similar to what the result of the DCM controversy was, which was that it produced a financial windfall for Hill's Pet Nutrition at the expense of other companies that were targeted or were the basis of scientific-ish stuff that really, for one reason or another, wasn't what the consumer really ought to have been focused on.
Wait, that is so fascinating. Can you dive any deeper into that?
Let's do that. Let me give it, because we touch on it with it. Of course, like this is science explained in great detail in the lawsuit itself. So let me give an overview of what we allege in the suit. So the document that begins the lawsuit is called a complaint. That's what our side, the plaintiffs, the people bringing the lawsuit, put together that says, like, court, here's our suit. This is what we say it is. Changes over time to some extent. The court might say something like, well, there's no evidence of this allegation, or this allegation is true, but it's not legally significant here. We know the court knows the law. What you're saying might be true, but that doesn't mean they owe you any money. Sorry. So it changes over time, but it begins with this statement of the lawsuit, a complaint. Sometimes it's very short. In our case, it's very long. It's 124 pages long. The reason it's really long is this is a complicated case that involves alleged wrongdoing on a lot of levels. It's always been, as this has all come together, you talk about the nature of the misconduct, the nature of the allegations. And like, I remember at first, like talking to like the lawyers, and it's a daunting thing to communicate the extent of the conspiracy that we allege. It's like, it took place on a lot of levels. And so it's this big, long document that goes into crazy details, all this different evidence that supports all the different points that are being made, whatever. And it's publicly available. When you file a lawsuit like this, the public can read it. And so I wrote a blog post that does the same thing as this interview does, but in the written form. And if you find, you should link it in the show notes, and you can follow that link and read the lawsuit for yourself. And you should, for a lot of reasons, right? It's the best place to go to find out what exactly the suit is about, what we're alleging happened. But it's also the case that you have to be really precise in the language that you use to talk about allegations at this stage, okay? Like, the legal system works in what's called an adversarial way, the court system, where it's like one party brings a lawsuit against another party, and the two, in essence, are opposed to each other. They're adversaries, where one side is saying, these are the facts. The other side is saying, no, these are the facts. One side says, well, taking these facts, here's what the law says needs to happen. The other side says, no. In light of these facts, this is what the law says needs to happen. And over time, what the court system does is it takes the best of those arguments and tries to figure out where the various parties are right and wrong, both with regard to the facts and with regard to the law, okay? At this stage of the suit, all that's happened is we have filed this lawsuit. So our side of it is out there, is in the public record. The defendants in the lawsuit have not filed their responsive pleadings yet. So we don't have their first version of, here's what we say about these allegations, which means that these are merely our allegations at this point. The court has not at this point said, we agree these allegations are true. In any of the countless allegations made in the 124-page document, okay? The defendants have not come forward and say, we dispute these allegations. We admit to these ones. These are true but incomplete. All that stuff, it's not there yet, okay? So all we can talk about at this stage, to be fair, to be accurate, is about the allegations that are set forth in the complaint. In addition, not only does fairness, reasonableness, common sense, and like decency require you to do that to be accurate, it's also potentially an area of legal exposure, okay? Filing a lawsuit containing allegations that you truly believe to be true, that you have evidence to support, is how the system works. And it is often the case that when people file lawsuits and make allegations, that by the time the dust settles on the case, some of the allegations have proven to be not true. Every defendant that goes through that, I would wager, would like to be able to say, they allege this thing about me to be true. It wasn't true. Shouldn't I be able to sue them for like defaming me as a result of that? And the general answer, my understanding, having worked in this area a fair bit, is that like there are important legal doctrines that say if you make a good faith allegation in your lawsuit, as long as it's made in good faith, and there are various standards that help to establish that, that's not a basis for defamation. You have what's called litigation privilege. You're allowed, that's the court system wants you to bring good faith allegations. And you're not held to the standard of if something is proven to be false in the allegations, you're automatically liable for defaming somebody. On the other hand, you could imagine that if you're not very careful with how you describe your allegations, you can wind up saying something different outside the context of the litigation. You could, in essence, say, we have proven that X, Y, and Z, when that's not really the case. What's the case is you've alleged it, you've set forth the evidence that you have for your allegations, and that's the stage that we're at this point. And so when I'm talking about the substance of the lawsuit, the very most important points to remember for the listeners are, number one, at this stage, they're just allegations, and the other side has not come back with their responses to them yet. Secondly, I have to be really general, really high level and non-specific when I'm summarizing those allegations in fora like this one, because there's very legitimate concerns that you could inadvertently end up saying the wrong magic words and say not what you intended and expose yourself to liability. And so what I'll describe now is A, pretty general, and B, merely allegations at this point. So I will, over the course of describing it, do my best to highlight some of the key evidence that supports the allegations. You know, it's not the case that all allegations are created equal, right? If you have, as part of your lawsuit, a video of the guy pulling the trigger, you have better proof of that than just like, well, his mother's cousin's friend told me that he pulled the trigger. Those are not the same quality of evidence, right? For the court, for anybody. And so we can talk about the evidence. That's just the evidence. That is what it is. And we can talk about what we allege the evidence shows. That's a factual matter that will be debated before the court and will ultimately get proven out. And then we can also talk about the legal significance of those allegations. That's kind of ultimately the court decides two things here. One is what the facts are. They weigh up all the evidence ultimately, and they say, this is what we believe the facts are. And what's the legal significance of those facts? The whole factual story that we set forth in the complaint could theoretically all be true, and the court could nevertheless say, yeah, but that doesn't mean you win a lawsuit. That just means these things are true. Theoretically, that's a totally possible outcome. On the other hand, the court could say, these facts together show that these people violated the law. This was the consequence. This is the penalty, etc. So anyhow, that's sort of the really legalistic introduction to what the lawsuit shows, or what the lawsuit says, and so these are kind of, generally speaking, here's an overview of the allegations. I already introduced everybody to the defendants, Hill's Pet Nutrition, which is notable as like the #1 vet recommended brand in the United States. That's a self-proclaimed label. That's not my research. That's what they call themselves. And a major chunk of their business is heavily intertwined with the veterinary community. They sell products, for instance, that are available through veterinarian offices. And so they have a sales infrastructure with sales representatives and materials and what have you that are designed to help veterinarians to sell those products to consumers. Okay. Hill's is also an old company, one of the oldest in the country. They were doing more than $2 billion a year in revenue. And like I said before, they have, more than any other company in the country, a unique relationship with the veterinary community, both the research veterinary community and the clinical veterinary community. In the years leading up to the FDA investigation, things were not going well for Hills. In the 4 years immediately preceding the FDA's investigation, and this is according to Hills is a division of a public company called Colgate-Palmolive. And if you're a public company in the US, you got to file your annual financial reports every year. You got to tell shareholders, investors, and the public everything that's going on in the business to some degree. And so one of the things they tell you is how much business did Hills Pet Nutrition do every year? And so I pulled you look at all those, and what they show is that Hills Pet Nutrition had entered a slide prior to the FDA investigation. The 4 years leading up to the DCM investigation, not only did Hills revenues went from 2.21 billion to 2.29 billion over 4 years. Basically over 4 years, they grew a total of 1%, which is, for all intents and purposes, flat revenues in the 4 years leading up to the FDA investigation. At the same time, the U.S. pet food industry as a whole grew a lot. And so Hills lost a lot of its share of that market. It wasn't just flat. It was losing market share every year. This market, this practice of selling through veterinarians, not going well in the years leading up to the FDA investigation. The FDA announces its investigation. It just so happens that it has the effect of moving consumers away from products not made by Hills. And as you'd probably expect, it has a huge, huge positive impact on Hills' business. And so over the 4 years before the investigation, it doesn't grow at all. Over the 5 years since the investigation launched, its revenues have grown from $2.2 billion to, they just announced their most recent quarter, and it annualizes to $4.2 billion. They've almost doubled in size over just the 5 years, going from a dead flat place to doubling in business, just about. So huge impact, very notable thing about one of the defendants. What we allege in the lawsuit is that Hills, acting in concert in a conspiracy with a group of other folks, 2 organizations, 5 specific veterinarians, set out to cause, in essence, the DCM controversy. That they intentionally created and worsened a scare about products where in reality there was nothing to be scared about. They did this in using let me make sure I'm following my outline here very well and giving everybody the right background info. Okay, yeah. As we explained in the complaint, the reason that it's not just Hills, that there's multiple defendants, is that they all had financial motivation to do things that are good for Hills. The veterinarians had received financial compensation either from Hills directly or through one of these intermediary organizations. Their vet school that they teach at got money from these organizations. They individually got paid for speaking arrangements or stuff like that. And it's all kind of set. You can read the specifics of that in the suit itself. But that's in general, why these people are a part of the suit too. That's the motive that we allege. They got paid by Hills, so they're working for Hills. And they engaged in this scheme that was creating a false controversy about DCM. Scheme has a few parts. The most important part, as we talked about before, the FDA's investigation came about, the FDA told the public that it came about because a spike of cases got reported that all had to do with these products all at once. Oh my gosh, we're scared. We're launching an investigation. The FOIA documents show that is not complete information. What they show is that spike of cases that the FDA received prior to launching its investigation didn't come from a host of different pet owners around the country. It came to a majority extent from 2 people. And they're defendants in the lawsuit. They're 2 veterinarians that have, as we explained in the lawsuit, have financial conflicts of interest with Hills that, in essence, collected cases that were about DCM and these types of diets and submitted them to the FDA all at once. And that, in essence, you can trace, the FDA gave me all the case reports. You could see where all the cases came from. The FDA says it received, prior to announcing its investigation, only 28 reports of canine DCM in the year 2018 leading up to the announcement of its investigation. So it's kind of not a very big spike in the first place. Of those cases, 21 of them come from just these two people. And that's kind of a notable thing. But it's not really, in my judgment, evidence that somebody's legally liable. It doesn't show, it doesn't suggest any kind of intent all that strongly. It's like a kind of an important fact, but there's a second fact that the documents show that in combination with that forms the basis for our allegations, which is that not only did these two veterinarians report the cases that the FDA was talking about, they cherry-picked the cases. They didn't just submit every dog with DCM to the FDA. They intentionally chose cases involving the kinds of diets that they were trying to cast aspersions on and submitted those to the FDA. And that whole process, why we allege that, it's based on, in the case of one of the defendants, it's based on an email, the attachment to an email that got produced as part of the FOIA materials that got produced to me, where she admits it. And the second one of those veterinarians, it comes from, I'm trying not to use their names directly. I mean, you can obviously find out who they are by reading the lawsuit, but I'm not sure it's all that helpful to do that. And it's unnecessary. The other one comes from publicly available stuff. She in essence, admitted it through the data that she presented at an academic conference around the same time, is the general nature of how it worked. But you take a look at the lawsuit, you can see. So in essence, we call this the cherry picking compartment of the scheme. They cherry picked, these people intentionally cherry picked cases, we allege, sent them to the FDA to make the FDA worried about something that they otherwise would not have been worried about.
And my question is, did the FDA just not ask questions? Did they just accept these and say, looks good? Where did you get them from? How did this come to be?
We will get to a point in the lawsuit where we get to ask the FDA those kinds of questions. At this point, I can't speculate too much about exactly how the FDA, all I've been given so far are FOIA documents. And in addition to that, there's a certain amount of public information that's available that helps you understand how the FDA was looking at this stuff. But yeah, we'd be speculating at this point, should the case go forward for long enough, absolutely, some of those people will get deposed and will have to give testimony under oath about how those conversations went and why things went the way they did. So that's sort of the cherry picking component of the scheme. The second component of the scheme is these two veterinarians who conducted the cherry picking part of the scheme also went out and put out false and misleading statements in both the scientific record and in public-facing layperson websites that were false or misleading about DCM and its potential link with these pet food products. They used a very specific term that one of them created to describe the group of products that they were alleging appeared to be associated with this deadly disease. They called them BEG diets, boutique exotic grain-free. This is a term that one of the defendants, this professor at Tufts University, made up and tried to kind of work into the discussion and the academic literature around this issue, even though that didn't really wind up ever happening. Very important term for the litigation, because in a way, it sort of describes the class here, right? She's saying BEG pet foods are the ones we all should be worried about. We're saying, no, you shouldn't be worried about those things. And so everybody that does make BEG pet foods that got damaged by you saying people should be worried, all of this lawsuit against you. That's another big component of the lawsuit. You can see all those specifics, every statement, every place the statement was made over the course of that might be, 70 pages of the lawsuit. It's just this website on this day, she said this. And that's why there's kind of 5 defendants that are individuals, is all those people were involved in that component of the scheme, where they were amplifying the significance of the FDA's investigation through false and misleading statements that were being made to the public. The final element of the scheme is there was a social media misinformation component where, in essence, some of the defendants used social media groups, private Facebook groups, and websites that purported to represent those groups to mislead the public further about DCM, about the FDA's investigation, et cetera. That's like broken off into its own component because there's a book that got written a few years ago by these professors at UC Irvine. It's called The Misinformation Age. And it's about, which is to say that like we are living in an age where the tools that powerful people, organizations can use to mislead using misinformation are new, novel, various, lots of stuff you can do. And it's taking place, unfortunately, on all kinds of different levels, including in the scientific world. That's kind of the focus of this book. And they talk a lot about, and other experts in this field talk a lot about the significance of social media to this stuff, right? Like by analogy, everyone remembers how like the Russian election interference issues were in Russian election interference used social media, particularly Facebook social media, to influence voter perceptions and behavior in the run up to the 2016 election. There's a component of the complaint that discusses how those same kinds of tools, Facebook groups and social media, were used to amplify this same false message. So there's that big component of the complaint as well. You can take a look at that. That's sort of the extent of it. There's a component of it that talks about the financial ramifications and how the financial trajectory of Hills was influenced by all this stuff, which I've kind of already summarized. You know, there's a big chunk, like this gets back to something you asked about before, that's about how this same type of playbook has been used by many of the same defendants in the past with regard to other issues. And so you definitely want to take a look.
That's exactly where I was going to back to.
Yeah, exactly. It's like there are in a bunch, you'll see characterizing the nature of the allegations in the complaint are like, this isn't the first time these same people have come up with other reasons why they say, well, the science unfortunately says the only good thing to feed your dog is Hills. We describe other instances where many of the same defendants use the tools of the scientific community, which is to say journal articles, textbooks, conferences, and their credibility that their titles as professors carry with them to persuade either the veterinary community and then through the veterinary community, the lay public, that there are diseases, health risks that the public should be worried about that are all attached to the kinds of products that Hills competes with. And you can see all those specifics. Many of them have to do with raw diets. You can see like how in the past, many of the same folks that are defendants here also put out science that's subject to the criticisms we voice in the complaint about raw diets that are also problematic in a variety of ways.
So what has the reaction been outside of just what you would expect?
Hasn't made as big news as the announcement of the FDA's investigation. You know, company files lawsuit is probably not as big news as FDA says it's investigating whether a disease. But it has, in the world of pet food, it has been quite high profile. It's received media coverage both from within the pet food industry and in some areas outside of it. And so that's what I was referring to earlier. There's been a good bit of that kind of media work that I've had to do over the past few weeks. Generally speaking, I would say that the news of the lawsuit has mostly at this point, as you kind of would expect, like confirmed people's prior beliefs. Like if, as I said before, there are lots of folks who have always been skeptical and suspicious about the FDA or the idea that grain-free diets increase the risk of DCM. The folks that went into, I'm generalizing and speculating about other people's state of mind, but you asked, like my impression is that the people that went into this lawsuit feeling that way, skeptical about this stuff, just makes them feel that same way. Whereas if you're somebody that went into it feeling like I am very confident that DCM is a real issue that really is linked to these products, it probably strikes you as, well, this is a guy who's not qualified to do this, and he's just greedy, and his company, he doesn't care about the fact that his company is actually causing this stuff. And so those are probably the two camps. At this point, has it changed people's perspectives about it? I mean, maybe, but it's all kind of speculative. The media coverage that I've seen thus far from like the reputable types of publications that cover pet food industry stuff generally has all been more or less fair, I think. There's a particularly good article that I thought in Pet Food Industry magazine where they bring in a lawyer from, it's like I responded to like one question they brought to me, but largely it's independent sources outside of me looking at the complaint and trying to piece together what they think about it. And so I thought that was really good.
Articles on pet food industry. So the one is written by Timothy, I'm spacing on his last name, but I will also link that in the show notes as well. Yeah,
I thought that was a good one. And then there are that's all the coverage it's received so far is like lawsuit alleges that blah, blah, blah. That's where we're at in the case. But the underlying factual circumstances that gave rise to it are, I believe, grounds for a much deeper investigation and the kind of reporting, investigative, that helps to explain all that stuff. And there are folks who are interested in that. But at this point, I can't say too much more about the nature of the work they're doing and the organizations they're affiliated with. But there's definitely interest. And
so we've
got a lot of feedback from like our customers, from other pet food brands that have been hurt by this controversy, by another group that's been totally hammered by this issue is like pet specialty retailers. Like the way that this issue has been framed has in a lot of ways been like, your mom and pop pet store that carries the pet food products that are like the better for you products, which is what in the industry is called pet specialty. Everything they carry is going to give your dog DCM. Sorry, don't buy there. And so a lot of those guys did horribly through this. And so a lot of them have been, I don't know, but I've always told them, get in touch with the same lawyers that we're using because they are at least looking at whether to bring additional claims on behalf of that whole different separate group relating to this same misconduct. And so, that's definitely something I encourage folks to do. But we got a lot of support from them. Some folks have come up with new relevant evidence about stuff that I've shared with the lawyers. So there's legitimate reactions from just about every part of the like pet food ecosystem, except for the defendants who have been thus far incredibly quiet. To date, they haven't like even told us who the lawyers are going to be representing them in the case. And we're now nearly 3 weeks since we filed the complaint. We've heard essentially nothing from them, which is their right. Kind of paraphrasing or characterizing other people's news stories. They haven't really given any substantive comment in any of the news stories that have been written so far. They've essentially said like, we deny the allegations and we're prepared to fight about it in court. And that's sort of the extent of it. But lots of other folks have been interested. Folks have done good reporting on it. We've gotten nice feedback that feels, this is obviously a scary thing for me. Like that's some of the people that are very tuned into the pet food industry have gotten responses from those kind of folks like, oh my gosh, this must be really scary for you. And it is really scary for me. Obviously, Hill's Pet Nutrition is a large, very important, significant company in the pet food industry with a lot of credibility in the bank with veterinarians. And this lawsuit calls that into question. And Hill's has a lot more money to throw at this than I do. And, they have a long head start of building inroads with the scientific community that they have a head start over me, decades. And there are plenty of reasons for me to be scared, and I am, but it also feels like the right thing to do. I'm in a very unique place to have brought it, right? Like I'm a lawyer. I've also done all this background stuff. I own a company that was on the bad side of this issue. And so it's a really unique kind of thing that made me feel like I had a responsibility to do it, knowing that other folks who were being harmed by it.
I think it's such an emotional issue too, because obviously DCM can be a fatal disease. And so
it's a real disease. Like that's sort of an important fact that's relevant to this suit is that like dogs were getting and dying of DCM before, during, and after the FDA investigation. Like, it's a real disease that dogs get. And the scientific community, many members of the scientific community are engaging in good faith efforts to try to understand why, what can be done to reduce the risk of it, and how do you treat it. And there are very effective treatments for a lot of forms of DCM. And so, but nevertheless, like, people have dogs that get sick and they have dogs that die from DCM. And, there's some of them that are like, I believe my dog died because it ate one of these products and it gave the dog DCM and that it died. And so for those people, this lawsuit feels like a slap in the face, I'm sure. And it's not my intention for it to be that way. I believe really strongly in the allegations that we've made about what the science doesn't show, how it was manipulated, et cetera. But I certainly empathize with people whose dogs have gotten sick from this disease, and people have lost their dogs from the disease. It's like, I'm hopeful that by the time like the dust settles on it, lawsuit's all done, the final word on DCM has been said, that there's broader agreement about what really happened here, what dietary qualities influence it, how are everybody's motives and all that. And I think that by the time that's all said and done, that the folks who feel resentful, or that's even like a loaded term, the people who are like not happy that I'm doing this will come to see it in a different light. Yeah. So you're right. There are those kind of people, and it's not, all I can say is that's not my intention. Like to say, I just legitimately do not believe that this stuff that was said was accurate. It's not to say that it is not the case that you can't give a dog DCM by what you feed it. You absolutely can give a dog DCM if you feed it the wrong nutrients. That is a thing. And it's not to say DCM isn't a real disease. It's not to say it isn't a serious disease. It's just to say that BEG pet foods don't cause that disease.
Yeah, and changing the narrative to reflect what is accurate.
Two more things, right? Okay, future. So that's where we're at. Future, what to expect. The next stage of the process is we're going to get the initial responsive stuff from the defendants in the lawsuit. There's several defendants. They might have different lawyers. They might have different strategies. The whole stage of responding to our initial pleading, our initial allegations is kind of what's next. It's going to take a period of months, potentially longer than that, just for that one stage. The wheel, you hear this cliche a lot, the wheels of justice turn slowly. It's definitely going to be the case here. This is a big, complicated case that is not going to make its way from inception to final judgment in less than a year. That is not going to happen. It's hard to say what the top end is, but you're talking about years. Like, set your clock to like years. This is not going to be just, something the court's going to figure out very quickly. So we will do our best to update folks that listen to this show, folks that keep up with Keto Natural or with, us, with important developments in the case, whether there are things the defendants say, whether there are things the court says, new things that we say, whatever the new developments might be. And that's sort of the way it'll go going forward. Second thing regarding the future is that, as I tried to articulate before, like doing this, trying to describe allegations is like this kind of fraught process where you got to be really careful about what you're saying, or try to be really careful. Because if you say, unintentionally say something that mischaracterizes the reality, you're potentially exposed to liability. And so it's made this kind of this weird, choppy conversation. However, and it's meant that like there are some things that I question, okay, I just won't say that. And so if folks are hear this and they have specific questions or feedback, hit us up. We have email that you can do through the show, their social media, whatever the channel is. Come and get in touch with us. Send us your questions. We'll probably, as long as we hear the same questions, get enough feedback, we'll do a show where we just address that. Because having that opportunity to digest that and think through in written form what the most accurate answers are is the best way to do it. And so this gives us a chance to do that. And so we'd really encourage that. If there's things that you read this and you don't understand that, or here's our thought about, all those things, just be in touch and we'll do more. Or don't, and we won't.
Excellent. Well, Dan, thank you so much for taking the time. I know that you have been extremely busy recently, and so I hope that you are maintaining a sane headspace. Thank you for letting everyone know what they can do if they have questions, Like he said, I'll go ahead and put a couple of emails in the show notes so you can reach out to us directly, and then we'll do a follow-up Q&A. Thank you all for your patience with us being late on our podcast, and we hope that you guys tune in to the next episode, which will likely be the Q&A. So thank you so much, Dan. Always a pleasure.
Yeah. Okay. Bye, everybody. Thanks for listening.